So what is an offer? What do you think an offer is? I'm going to stand in the middle here. I'm not ambi-turning today. What is an offer? Go on, Stephanie. I think you know what an offer is. You're prepared to have a go.
If they're willing, I remember that was a key term, a willingness to...
A willingness to enter into an enforceable arrangement of some kind, an enforceable agreement. So an offer is the indication by the offeror to another person. We refer to them as the offeree. You'll notice when you come across these nouns, legal nouns tend to have an or and an e. The trick for young players, actually, you need to know this at the moment, is mortgagor and mortgagee. Okay, so if you borrow money from someone and you give them a mortgage, a form of security over some property, say your house, you are the mortgagor and the bank is the mortgagee. I just say that because there's a little bit of legal trivia that makes you just sound really smart. If you need it in a conversation, you can just whack up a conversation with your partner about the mortgage and say, you know, as the mortgagor. And they'll look at you and you say, I'm a law student, I know. But basically, offeror, offeree, it works the same way. The person who gives or makes something has the or, offeror. The person accepts or enters into something is the offeree. So an offer itself doesn't create the contract. We need an offer and acceptance to fall in love and make an agreement. It creates in the offeree the power to create contract by accepting the offer. Now that's a really interesting piece I want you to think about. The moment that an offer is made, all of the power goes to the offeree. So, what is the nature of an offer? I've already mentioned objective test. Cases in support of this idea of the objective test are many and varied. Carlill and Carbolic smoke ball is a very good place to start. A very good Australian authority in relation to that is Taylor and Johnson. But you will have no difficulty finding cases that state that we need to apply an objective test. So because it's an objective test, the intention of the offeror themselves is irrelevant. So if objectively it appeared that I owned everything in this university and was able to sell it to you at any price I liked whenever I liked, it would not be relevant that I thought I was being hilarious and that it was just all a big joke. What is relevant is whether a reasonable person would have assumed or understood by my words and my actions that I was making an offer, that I was willing to enter into the agreement. So that's how intention is ascertained. Offers can be made by an individual, made to an individual, a group, or the world at large. Quick little side note. A company, is a company an individual or a group? Or neither? Is it something different again?
A body corporate.
It's a body corporate. So what pronoun do I use? Him, her, they, it, them?
It might be.
It is a very good pronoun to use with companies. Of course, you know, we understand that being a company is a spectrum, and some companies appear to like to be called they. But a body corporate is a singular entity. Under the law, a body corporate is a legal person. It has capacity to contract, to sue and be sued in its own name. So it is an it. I've seen partners in major law firms refer to bodies corporate as they. you know, and them, because a company usually has many people involved in it. It's not a stupid way to deal with it, but technically, again, if you want to show off and be a technical lawyer, and let's face it, that's what I want you to do because I love giving good marks, we use it. But also, a company can be a party to a contract. So even though it's a human being who's making the offer, necessarily, when we're talking about a conversation, the contract, in fact, might be with a company, that human's employer, or where the company is a director. Please stop me if you've got questions, because I'm going to throw a lot of this kind of information in for the first couple of weeks. The offer, also we've discussed this, needs to provide all the information required so the terms can be identified when the offer is accepted. It needs to contain certainty. And that means, as Aisha pointed out before, we need to be able to identify from the offer what the consideration is. Even though it's a little bit wordy, I think this is one of the better definitions of what an offer is, even though it's American. An offer is the manifestation of willingness to enter into a bargain, so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. An offer is a statement of your willingness to enter into a binding arrangement, made in such a way that means a person who hears it will understand that all they have to do is agree, and that will mean that the agreement is made. I like to plain English things along the way. When you're reading cases, it's a really good idea to just stop and translate every now and then. I actually find, because of the way our brains work, doing that out loud is a really helpful thing, because our brains will listen, use different parts of our brain for our listening and speaking than we do for our writing. The more different bits of your brain you engage in learning, the more likely you are to make sense of it. So I want to talk about this case as an example of offer and how the ideas work. So this was in the casebook, Gibson and Manchester City Council. Just point out a couple of things along the way. This number here in the brackets, what is that? The year that the case happened, the year that the case is reported, what is it? Sorry, I heard reported. And yeah, you are right. And you are right. So this is actually an appeal case. So appeal from the Court of Appeal in the House of Lords. In square brackets, whether they're square brackets or round brackets depends on the type of reporter that it is. But the note here, the date in brackets is always the year of the report. The next number is the volume. So this is WLR, which is something law reports. Sorry, weekly law reports, is that right? Thank you. Can never remember. I just know their House of Lords ones will be there. So volume 1 from 1979 of the weekly law reports at page 294. So if you were to go and find the volumes of the weekly law reports, that information will help you find the physical book. This is part of my beef with AGLC4, is you're not going to do that, right? You're going to look for it online. So why? Like, what's the point of a citation? Appears to me to be twofold. One is to acknowledge your source and give it credibility, give your work credibility, and secondly, so other people can find it. This is actually not particularly useful for other people finding it anymore, but it was useful when I was a girl, so let's go with that. But yeah, so the 294 means this case begins on that page, 294. If I am quoting from a particular page or paragraph of the judgment, I would want to see you pinpoint that. So that means you would have all of that with a little comma after it and the page number from which it came, which again is ridiculous when we're looking at it online, but just so you understand where it comes from. For us, we're looking at it in the casebook. So you'll find it at chapter 3, paragraph 15. So the facts of this case go back to 1970 when the Manchester City Council decided that it was going to sell council houses. The picture here, anybody been to Manchester?
Yes.
I'm judging you. I had such a good time in Manchester many years ago. But yes, this is what Manchester looks like. Most people who've gone to Manchester and done it properly didn't actually go anywhere during the day, so you wouldn't have actually realised just how dreary and dull it is, because everywhere you went it would have been noisy and there were flashing lights, right? But this is what council houses in Manchester look like. And they're called council houses because they were in fact owned by the council, and people lived in them for very long periods of time. And the Manchester City Council decided that it was going to adopt this policy of selling the houses to residents, and Mr. Gibson was one of their tenants. So he applied to the council to find out what would be involved in him purchasing the house. So in fact the council were also offering effectively to vendor finance. So they would lend money to the purchasers would give a mortgage, so become the mortgagor over the property as security for the money that had been lent, and then pay it back. So effectively what the transaction would look like is instead of paying rent, they would be paying mortgage payments and end up owning the house. So Mr. Gibson wrote, and he received a letter back from the council in February 1971 that stated, the council may be prepared to sell the house to you at a price of 2,180 quid. If you'd like to make a formal application to buy your council house, please complete the enclosed application form and return it, blah, 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 blah. So in fact, rather than me summarise it there, here is the letter that he got, or the pertinent parts of it. I refer to your request for details of the cost of buying your council house. Corporation may be prepared to sell at the purchase price of just over 2,000 quid, or almost 3,000 quid I should say, less 20%, blah, blah, blah. They've set out how long he'd have to pay for it. There's quite a lot of detail in here. It even says if you wish to pay off some of the purchase price at the start, you'll need a mortgage. The monthly instalments might change, blah, blah, blah. So quite a detailed letter. He completed the application. He didn't put in the purchase price, he left that blank. And then he signed the form that ends with the words, I now wish to purchase my council house. And he got it back on the 5th of March, so 3-4 weeks later. However, in the interim, there was a local government election and the other guys got in. And the other guys got in with a policy that they wouldn't be selling council houses anymore, that they would be continuing to own that asset and collect the rent, and that they would deal with their issues, their cash poor issues in some other way. But Mr. Gibson then argued that there was already a binding contract and that they had to sell to him. So he argued that that letter on the 10th of February was an offer to sell, and his return of the application on the 5th of March was his acceptance. So he got an offer, that quite detailed letter, and he signed on the bottom of the form saying, I now wish to purchase my council house. So there was an offer that matched an acceptance. So the question became whether the correspondence between the parties created an enforceable agreement or not. So the question then came to to what kind of test should the court apply. But before we even go to the test, I'm talking about this with offer, and Mr. Gibson is saying, well, I accepted an offer. So clearly, I'm more interested in the offer today than I am in his acceptance. We'll talk a little bit about acceptance last week. So the question really goes to, let's say that there is no doubt that there is an acceptance. I think you probably might be able to see some ways that there might have been doubt about whether there is acceptance. But for argument's sake, let's assume there was an acceptance. The question then becomes, was there an offer capable of acceptance that would create a contract when that acceptance happened? So the courts took what they call a conventional approach. They looked at the documents and just had to look at whether on their true construction there's a contractual offer and an acceptance. So what does construction mean here? I'll give you a hint. It doesn't mean building things with Lego. So construction here doesn't mean anything to do with building. What do we mean by the word construction in relation to a contract? I can put it in another form. How did the court construe the contract? What was the proper construction of the contract? So I heard wording. I think we need something a little bit clearer than that. Elements? Yeah, the construction, probably another synonym might be correct understanding. So how do we understand, what does a court understand those documents to mean? What is the legal consequence of those documents or those words? So the construction of a contract is, how do we understand the contract? And it does come from that idea of building. So what documents and words build to the promise? So again, I know I'm going to keep going to these tiny terms, but being clear and specific on the terms is half the magic to this subject. So let's go back. I've highlighted some terms now in this letter. The corporation may be prepared to sell the house to you. If you'd like to make a formal application to buy your house, enclose the application or complete the enclosed application and return it to me. Does this impact our idea of whether it's an offer or not? Nah, you've just pissed him off, haven't you? Gibson's got no chance at all.
If you were an invitation to treat with the language, may be prepared.
May be prepared.
If you would like to.
I think that is the proper construction, that it is an invitation to treat. Remember, all but 15 minutes ago, we were talking about how once an offer is made and an agreement can be made simply by acceptance, that all of the power is with the offeree. So the council here doesn't want to give up its power. It's quite a common way of structuring agreements. So what it's saying is, we might sell it to you on these terms, but you have to make an application to us. So you have to make an application, you have to put the price in. Now, why would the council want to do it that way? I mean, it could just be like, unlike some state governments in this country who like to enter into contracts like 30 days or so before an election. It could have just been that they were trying not to be like that. But why else might one party... Billy?
Does it go to what you were saying earlier as to the power rests in the offeree?
The power rests in the offeree. So once, if they make an offer, Mr. Gibson just has to sign a form to accept it. And they actually have no idea whether he can afford the mortgage payments or not. They have no idea whether he's a tenant in good standing or anything like that at that stage. So it's quite common for commercial arrangements to be structured so that there is an invitation to treat and that a purchaser makes an application. So the purchaser is often the offeror. Make sense? Not always, but you need to look for that. You need to understand who's technically making the offer and who is entering into the agreement. So the court held in this case that those words, may be prepared to sell, if you'd like to make a formal application to buy, made it impossible to understand the letter as a contractual offer. The letter and the application forms simply set out the financial terms on which they might have been prepared to consider a sale. And the terms themselves, it might be that they never had any intention of changing those financial terms, but they would only sell if he had a regular job, or that they were satisfied that he could make the payments, or that they were satisfied that the house itself was safe, or that they were still in office, as it turned out. So they weren't actually even setting out the basis. So they weren't conditions precedent to acceptance being available. They had actually flipped it so that acceptance, the offer was being made by the purchaser. No contract. So is this a fair decision? Poor Mr. Gibson. Aisha's up there, she's like, no, she's working for the tenants union and ensuring that, you know, people get looked after. You need to tell me your names.
Clay. Regardless of the misinterpretation, it says that it's not an offer of a mortgage in the letter.
Sure.
It very clearly says in the original letter that this is not an offer of a mortgage.
It's not an offer of a mortgage, absolutely.
So why did he get confused when it very clearly states that it shouldn't be?
Sorry, let me go back to make sure we're all talking about the same thing. So it clearly says the maximum mortgage the corporation will grant is that. If you need to get it somewhere else,
Just above the last,
well,
the last sentence in the second paragraph.
letter should not be regarded as a firm offer of a mortgage.
Yes.
But the question wasn't over whether he was offered a mortgage, the question was over whether or not he was offered the house for sale. So there was vendor finance. So there's a few complicated here. So one is, and it's kind of bizarre that they use that language because it doesn't really mean anything. And technically, if you look at mortgage documents, for those of you who are lucky enough to be in that cycle of poverty that is having a mortgage, if you look at your mortgage documents, you will see that you are actually granting it. But colloquial expression is, I got a mortgage from the bank, not I gave a mortgage to the bank. In this case, we've got they own an asset. They are offering, well, they're not offering, but they're discussing the potential for selling the house and also financing the sale of that house in exchange for a mortgage. And they're clearly saying, we're not offering you the mortgage, whether or not the question is, actually, did he believe he was going to get his house? The other contextual thing that we need to know here, and I think probably one of the reasons that Aisha is going to stand up for Mr. Gibson here on a question of fairness, is that this had been going on for some time, and people who had filled in that application before there was a change of local government were able to buy their houses, and that they did enter into those contracts. So it was for him. So there's this precedent of other people who've been able to do it, but they had also gone through the other parts of the documentation process. So, you.
Yeah, my name is Tina. Actually, for the case of Gibson, can we still argue the offer is not clear because it says the publication form has to be returned as soon as possible. But how many days? How as soon as possible it will be?
Well, I think it's a really, really good point, okay? But we need to just step back one. If it were an offer, then yes, it needs to be clear. In this case, for other reasons, it's already not an offer. But if everything else had been clear, the next question becomes, did the offer lapse? But we don't even have an offer here. So your question around timing goes to whether or not the offer might have lapsed, because you're right, it's roughly a month, isn't it? It's the 10th of February through to the 5th of March. So February is a short month, so let's call it 3 weeks, a bit more than 3 weeks. Again, if it doesn't say anything, and we'll talk about what to do if an offer lapses in relation to time, for a significant financial investment, and something that is a big decision, you know, we're talking about people who have never owned homes before. 3 weeks to make a decision doesn't seem to me to be an extraordinary period of time. Now, if it was 4 years later, I'd say absolutely. but we didn't have an offer already, so that ceases to be the issue. But 3 weeks, soon as possible, well, I think if he was looking at alternative finance, 3 weeks is actually pretty fast to get an alternative loan and offer and things like that. So I think, yes, you're right. If I were acting for the council, I would have made sure that that letter was a hell of a lot clearer on numerous points. So going back to, was it Claire? Clay. So going back to Clay's point earlier, another argument that you might run in relation to the letter is because it was so clear that it wasn't a mortgage, it's reasonable to believe that it is an offer for the sale of the house, for example. Again, because, and we'll get to some construction of terms as you move through towards the very end, but as a general rule, a court will say that if you use the same word or similar words, if you use the same word over and over again and then you use something different, we will assume you meant something different. It's kind of a, so if we talk about the IT hardware, all the way through the document, and then we talk about the mobile phones, we will assume that you're carving out the mobile phones to treat them differently from other IT hardware, even though one would think mobile phones is a subset. But lawyers will treat that language differently. So this question did exercise the minds of the judges, and Lord Diplock said, whether one thinks this makes it a hard case perhaps depends on the political views that one holds about the council's housing policy. But at the end of the day, this was a political case. It was a test case. But hard cases offer a strong temptation to let them have their proverbial consequences. It is a temptation that the judicial mind must be vigilant to resist. Just because it doesn't seem fair doesn't mean that we need to change the law effectively. So why is that? Surely courts can come up with a fair result. Isn't that what we expect from them? Clay?
It would just never stop. Like, yeah, if you tried to amend it for this one person, you'd have to do it for another person, and it would just be very, very messy.
Yeah, it would be messy, exactly. It would never stop. I think that's excellent language. And again, going back to why do we have contract laws? So that when commercial people enter into contracts, they know that they're going to be dealt with in a consistent way.
Tara?
Hi, Tara.
Hi. So wasn't Margaret Thatcher the one that introduced that policy? So why did it become an issue?
I do know that it was privatisation generally was clearly part of Thatcher's regime. But we're talking about local government here as well. So I actually have no information or knowledge about the extent to which there was any link between the Tories and the end result here. But at the end of the day, these are, again, if you think about major privatisations that have happened in this country, Snowy Mountain Scheme, that's New South Wales government. Gladstone Power Station was Queensland government. Loy Yang A and B was the Victorian government. Then we go down to the local council level, local libraries and town halls and things like that. So they're dealt with at the council level. So again, it's not at all unusual to have different political states at different levels, particularly in 70s Britain. Stephanie.
I just want to go back to what you were saying before about how the ambiguity of writing by the council and by other commercial entities use that ambiguity in order to sort of reverse the offeror role.
So is it using the ambiguity, or is it actually structuring the way that they do commercial deals to ensure that they have control over who they enter into a contract with or otherwise?
Yeah.
So another example of that might be entering into a mobile phone contract. The terms are not negotiable on the whole. In fact, they can be really hard to even find. But you go to a store or a website and they say you can have, in Australia we have this bizarre thing, you can have X number of minutes for $60 and you can have X number of texts and things. And of course it's kind of meaningless because you know, the cost of the minutes depends on a range of, they're very hard to compare. But basically they give you all of this information, you pick a provider, but then you have to apply. So you're effectively making an offer to enter into a mobile phone contract with somebody based on terms and conditions that they make available, maybe, but you're making the offer.
The second part to this question is just
sorry, I jumped.
Is that sort of so Gibson in this case thought he was accepting an offer, but the situation is that he wasn't, which I think kind of the processing was a bit unfair in that situation because he thought he was in a position of power.
Well, he thought he look, subjectively we don't know what he thought.
Yeah.
Objectively, what we know happened is there was a change in the government and he became a test case, and that was what the argument is. We don't know what he actually thought. And ultimately the court found that it was using an objective test, that there was not an offer capable of acceptance at that point. So subjectively, he may well have. I'm sorry, the way that I said that was intentionally to get to the point of we need to look at it objectively to find out, is it an offer or is it not an offer? What he actually believed could have been anything, really. And it becomes an issue in particularly when we have marginalised people with less education or less ability to access the information. And I think also we get terms and conditions fatigue. I'm a contract lawyer. I teach contract law. I just entered into a new NBN contract without reading the terms.
But he's so crazy, 100-page terms.
So, you know, I mean, but, you know, it's an interest of mine, you know. Like, at the end of the day, we get term fatigue. Oh, if something goes wrong, I'll pull them out. But again, that's sometimes what contracts are for, aren't they? It's for dealing with what the dispute is at the end. So, we're going to talk about Carlill and Carbolic smoke ball now, and then we're going to end it for today and continue on when we have a tune. So, I call this learning about what an offer is by exploring all the things that an offer is not. Just like learning about how to write a contract by studying cases is about learning how to have a good marriage by only talking to divorced people. So the case, Court of Appeal, goes back to 1893. I am very much hoping that you got a broad sense at least of what the facts are. On the slide you can see some of the advertisements for this product that were in newspapers all over what we now call the United Kingdom back in the 1890s. So basically these are the material facts. The Carbolic smoke ball, who are the defendants in this case, produced this thing which apparently looked a bit like that. It's a smoke ball. I don't know, it's like a little device for putting the equivalence of Vicks Vapor Rub up your nose, I assume. I'd love to find out what it looks like at some stage. Basically they said that their product was so good that if you used it in accordance with the instructions and you got sick, got influenza in particular, and remember this is just after the Spanish flu, which was, the Spanish flu was like Ebola on steroids. Like it wiped out a huge proportion of Europe in one go. So people were very nervous about getting the flu. And they offered to pay £100 if you used it in accordance with the instructions and you got sick. It also stated that they had put £1,000 into their bank to show their sincerity in relation to that matter. Mrs. Carlill bought and used the smoke ball. She did what it said on the tin. She got influenza. She went and asked for £100. They said, no, that's not for you. And so she sued them for her £100. All right, there are significantly more going backwards and forwards in the fact than that, but I think that's what's important for our case today. This is what the advertisement looked like, and these words come directly from it. A £100 reward will be paid by the Carbolic Smoke Ball Company to any person who contracts the increasing epidemic influenza, cold, or any disease caused by taking cold after having used the ball 3 times daily for 2 weeks, according to the printed directions supplied with each ball. 100 quids are deposited with the Alliance Bank, Regent Street, showing our sincerity in the matter. £1,000 is deposited. Okay, I think it's worth pointing out that that is, so the £100 in today's dollars, I did the time value of money calculation and translated it into Aussie dollars today, $23,926.07. So this is effectively, let's translate this into today. Soldier on, take a Codral, go to work. If you still feel sick, we will give you $23,926.07. Would you believe it? Okay, I'd just like to point this out because, look, there's a whole lot of issues with this case. And I think it's really easy to look at these words to say, 1,000 quid. They put 1,000 quid showing their sincerity. It's £100. You know, so we're asking ourselves the question really, is this piece here, is this a binding promise? And it looks and it feels like a binding promise, and then all these things happen. And so you're sort of looking at it, and then, like the Carbolic Smoke Ball is saying, it was a puff. It was just an offer. You know, it was not ever meant to be taken seriously. And that's why I think doing that calculation helps us actually put it into some context. And I would suggest that you do that when you're reading particularly these old cases. So is it Michael over here? Michael over here mentioned that he did some contract law stuff back in 1992. So 27 years ago. I said, oh, it hasn't changed much. And it really hasn't. You would have read that case back then, right? And this, it's basically, again, so that everybody knows you're a law student, you only really need 2 cases, like Carlill and Donahue and Stevenson. Like, that's all you need. That's like everything everybody needs to know. Beyond that, you can prove, no. Seriously, you can use Carlill as almost, like if you're running out of things, you can almost use it for anything. You can always find something better, but if you get desperate. But I think putting it into some context is a really important thing to do, because just doing that maths made me think slightly differently about the case. So the issues here ultimately go to whether that statement in the advertisement was a promise that should be binding or not. So was there an indication by one person to another of their willingness to enter into a contract on those terms without further negotiation? Was that statement in the advertisement an indication by Carbolic Smoke Ball to Mrs. Carlill of their willingness to enter into a contract with Mrs. Carlill to pay her 100 quid if she did what she had to do, take the Carbolic Smoke Ball 3 times a day in accordance with the instructions on the packet, and she still got the flu anyway. And that ultimately translates in the case to, was this an offer to contract or merely an advertisement or a puff? Now, part of the problem here too is that this is an 1893 case. So we didn't have a product liability law at that stage. The law of tort was sort of dwindling a bit. I don't know, Tina makes it sexy, but you know, I think back then, contract, we were in our heights. And so contract was the choice that the lawyers made to identify this. Now the thing is, you guys, it's easy. It's Monday night, it's sometime between 6:30 and 8:30 at night. We're going to talk about a legal issue. Chances are it's going to be a contract law issue, right? We don't have to think, is it a tort issue? Is it a crim issue? Is it a product liability issue? Is it an equity issue? How does it fit? Is it a wills and estate issue? So we know it's going to fit somewhere into contract at the moment. But when we work the other way around, when we've got a client who has a problem, I've got the flu, I thought I was going to get $100 or 100 quid, and not only that, there are all these other people around who are buying this product based on the sincerity of the offer, and you want to put a stop to that, you've got to work out which branch of the law to fit it into. And at that particular time, contract was the most appropriate branch, or so the people who brought this case thought, and thank God for them, because we have this case. So the defendants argued the following. They said the ad wasn't an offer. There was no direct expression of a promise, and they didn't intend a promise. They never intended to pay that amount of money. They said it was a puff, it was a boast, and it wasn't meant to be legally binding. They also said, and lawyers will do this a lot, even if there was an offer and it wasn't a puff, then Mrs. Carlill, even if she accepted the offer, she didn't communicate her acceptance to us. And in order for a daddy offer to have and a mummy acceptance to fall in love and create a baby agreement, we need to have communication of acceptance.
They did not stipulate any condition.
So there's lots of different arguments here. I just want to go through what the defendant said first, okay? And we'll get to the other side. I mean, I'm assuming I'm not spoiling this for everybody. You have read this case, right? I'm just pulling it apart. If you haven't read it, like, come along for the ride. But yeah, I want you to. There is value in these cases in reading both sides of the arguments, because then you see which way it falls. But you can also see the reasons why arguments were rejected, and they're very rarely wholesalely rejected. So you can find ways of actually examining the point with more detail. So you need to read into the detail. They also argued that the advertisement itself was too vague or too uncertain. For example, there was no time limit for getting the flu. So going back to, is it Tina? Tina, clearly assisting counsel on this particular matter, had pointed out to them that, the way it's written, it was clearly way too uncertain and vague. All she had to do was take this carbolic smoke ball for, the 7 days or 14 days or whatever it was. As written, she might come back and make a claim 15 years later. Well, that's ridiculous. So Lack these arguments. They said, well, it doesn't matter that it wasn't a direct offer to Mrs. Carlill. It was an advertisement which was an offer to all of the public. The other language that we use is the world at large. As soon as Mrs. Carlill did what the advertisement directed, she'd entered into a contract. She said, this is what a unilateral contract is. That all she had to do was do the thing. She had performed her side of the bargain, using the product in accordance with its directions. And so that meant that when she fell ill with the flu, she was entitled to claim the 100 quid. So the judges ultimately agreed with Mrs. Carlill's lawyers. And as a consequence of this case, we get a number of propositions. So I'm highlighting a couple of them here, but there are a number that will flow through. Firstly, you can make an offer, if it's a unilateral contract, you can make an offer to the whole of the world. You can make an offer to a specific part of the population. You can make an offer to an individual, but the offer itself only ripens, their language, into a contract when someone comes forward and performs that condition. So it might be, if the offer is made to a particular category, so I make an offer to all students of contract law that they can join me for an online tutorial at, what time did we agree? 6:30 on Sunday night, that's Melbourne time. And that will ripen into a contract well, it's actually already part of the contract we have, but hey, if I was just offering it randomly, it would ripen into a contract when you show up at that point in time. So if you showed up and I didn't, effectively I would be in breach of the contract at that stage because you've done everything that you needed to do. By the way, you have to bring your own booze. I'm not getting a glass of wine for all of you. No wine until after the shoot. How many times do I have to tell myself that? Acceptance of a unilateral offer occurs by performing the condition. Okay, all she had to do was do it. So in this unilateral contract situation, acceptance doesn't need to follow immediately. So because it would be unfair and it would be contrary to our understanding of how the law should work or how commercial practice should work, if I offered you 100 quid if something went wrong, and as soon as something went wrong but before you told me that something had gone wrong, I withdrew that offer. Can I take, I know I said I was try and finish just before 8:30, but I reckon we can have just a 5-minute chat about unilateral and bilateral contracts before we go on to the next thing and I let you go. So unilateral and bilateral contracts, we kind of talked about this when we did the quiz earlier on. Features of a unilateral contract. We have two parties. Let's call them A and B because we have no imagination whatsoever by this time of night. One promise is made. A promises to pay $100 to B if B finds A's lost puppy. B accepts the offer by performing the task. The contract is formed at the time B performs the obligations under it. So if I put a sign up and down my street, picture of my puppy on it, say lost puppy reward, I am not bound to pay anybody unless and until somebody fronts up with the puppy. Okay? If at any time before they front up, I pull down those signs, or I go and write in big black text or all over them, offer withdrawn, or don't care, it was always a stupid puppy anyway. Actually, for those of you who hear my recordings, you will often hear my stupid puppy barking its head off in the background, and I should apologise for that. So this is why they're called unilateral. The unilateral, in Carlill, one of the judges, I can't remember who it is at the moment, mentions that the idea of unilateral is a misnomer because it doesn't mean one party, it means one party at a time. So the offeror only has an obligation when the offeree has performed the task and as a consequence has accepted. So it's at that point the contract is created, and at that point there is only one set of obligations left. So this is my attempt at drawing it up. So an offeror, they do what offerors do, they make an offer. At that point they have no obligation and they can withdraw the offer at any time. The offeree has absolutely no obligation at the beginning to do anything. But if they do what the offeror asks, then a contract is made. An offeree could be anyone. So if the offeror stipulates a particular class of people, that's fine, but the offeree could be anyone at all. No, my point exactly. Isn't that amazing how I wrote that some other time? The other thing that's important here is that they need to do what the offeror has asked them to do, the stipulated task, before the offer is withdrawn. If the offer is withdrawn, too bad, so sad.
It's also true that the offer can't be withdrawn in the middle of doing the action.
Yeah.
Is it also true that the offer can't be withdrawn in the middle of doing the action? What do we think? What's your basis for this idea? Sorry, and what's your name? Fabian.
Mobile? Yeah.
Mobile?
Mobile.
Is that what mobile says? We will come back to mobile on Sunday. Again, the answer that everybody hates, it depends. So let me use my lost dog example. If you'd seen the sign up and you were happily looking for my lost dog, and then while you're doing that, I'm going around pulling the posters down, you show up with my dog and I'm like, oh no, I thought it was Rosie that's gone. Turns out it was Harry, you can keep him. That is actually something that might happen at our house, by the way. I don't think you would have any claim. However, as was the case in mobile, well, mobile moves around in a range of different ways, but if I am aware that you're doing that, I am encouraging you to do things in a particular way, then maybe I would be stopped from withdrawing my offer. But mobile is, I don't want you to take that as the last word on mobile, because it is a more complex case than that, and we will go through it bit by bit, and it gets appealed and reappealed, and it's complicated. So once a unilateral contract is made, the offeror is bound and the offeree has rights. Contrast this with a bilateral contract, very messy, I know, but our offeror has rights and obligations, and our offeree has rights and obligations which become executory at the point in time when the contract is made. So as soon as the offer is accepted, then both parties have obligations, both parties have rights, and that's where we go from there. So let us finish at that point. I will most likely, I'm trying to work out the best way to condense these into 2 hours. I will most likely put a couple of video case studies up in the next 48 hours or so, around the time that I put up the recording for this class. And then we will see each other on Sunday night at 6:30 Melbourne time. There will be a reflection exercise. I would really appreciate it if more than 6 people did it. It really does help me focus my attention in the class. And if you're lucky enough to be one of the only ones who does it, and there are only 6 of you or so, then I will be focusing my attention on the stuff that you tell me I need to focus my attention on. That goes for you too, my lovely online people. Have a fabulous week. I will see you all on Sunday at 6:30. Please wear clothes or keep your cameras off. Just saying.